Welcome to CC Partners, the employer's choice. We provide expert legal and strategic advice in all areas of labor and employment law. By working closely with our clients, our experienced team delivers pragmatic, proactive solutions, resolving many issues before they escalate. Get to know us better at ccpartners.ca.
Okay, I'm going to share the screen again for the question and answer period so we can see the questions that have come in, and we're trying to incorporate as many as we can here. And just give me one moment. That screen will be shared. Okay, so before we move on to the questions, there's one that's been coming up and one that we've discussed amongst ourselves here at CC Partners, and that is, okay, we know that Regulation 288-20 doesn't specifically include reference to unionized workplaces. Is there any effect or implication for unionized workplaces of this amendment to the ESA in the form of the regulation? And to that, my thinking is that all this does is reinforce the somewhat novel legal argument that I've put forward and that many of us have put forward from the beginning with our unionized employers, and that is simply that what is happening now, especially if you are forced to shut down rather than just experience a downturn in business, is that this is not the type of layoff that is contemplated by the collective agreement and that was contemplated by the parties. Now, every collective agreement interpretation issue comes down to the language of that collective agreement. But as a general principle, I think there's at least an argument to be explored for unionized employers that, this is not a layoff as contemplated when normal layoff is talked about. And I recognize that some employers do have force majeure clauses and so on that may or may not address it, but the absence of that language to me is not fatal, especially when you have now a legislative move by a government in Ontario and other moves in other jurisdictions across Canada that indicate that's how it should be. These are strange times and they require some special considerations. That's the kind of biggest implication that I can see. And again, everything turns on the specific wording of your collective agreement, but we know how it applies in the non-unionized context, but I still think it has value in kind of underpinning the legal arguments that we've already been making with respect to these leaves of absence rather than layoffs. Any of my colleagues want to comment, feel free to do so.
I'll chime in just a bit. The regulation does talk about union workplaces and employees represented by unions, and it says that the regulation itself, insofar as the deemed infectious emergency leave, do not apply to collective agreement workplaces. But other than that, I would echo everything, Kelsey, that you just said. Just because the regulation itself is deemed not to apply to a union workplace doesn't mean that we don't have arguments to make about how our collective agreements need to be interpreted and applied in the current circumstances.
Yeah, thanks for clarifying, Mike. And when I said that it doesn't include, I should have been more specific to say that it specifically says it does not address. But yeah, I mean, it always comes down to the language of the collective agreement. But absent any language, I think that's the point that we're getting at. It should inform the way we look at our collective agreement language. Okay, so moving on to the questions. Here we have a fairly common one, and this one was kind of, as Christina was talking, I had this specific question in mind, and I'll try to make sure that everyone can read it there. So a large number of employees laid off, as has been common for many employers. And what happens? Who wants to field this question and the hypothetical example there while everybody's reading it?
So the question is, what happens with our employees who were put on layoff before the regulation came into effect and who we do not expect we're going to be able to reinstate within the 6 weeks after the state of emergency is lifted? And remember, in that regulation, this is our COVID-19 period in which otherwise presumably laid off employees are deemed to be on a leave of absence instead of on a layoff. So what do we do with these employees? How does the regulation apply? Keep in mind what I said about layoffs under the Employment Standards Act, that a week of layoff, the Employment Standards Act includes a provision for what is called an excluded week. And an excluded week includes time where the employee is not available or not able to work. If there's an excluded week, that does not count toward the 13 weeks or 35 weeks of layoff time. It does, however, count toward the 20 consecutive week period, or the 52 consecutive week period in which the temporary layoff may occur. So, and we don't have official guidance on this yet in terms of any kind of case law or decisions or binding authorities or interpretation. But I have to think, based on the rest of the language in the Employment Standards Act, that an employee who was laid off prior to the COVID-19 period under the regulation could have essentially their layoff period expire, depending on how long the state of emergency lasts. And then if after 6 weeks from lifting the state of emergency, there is a need for the employee to be on layoff, and it can be done pursuant to the terms of the Employment Standards Act, that restarts the clock, so to speak. So again, we don't have authority on this, but the way I'm reading the legislation, that's the interpretation that makes sense, and that's how I'm viewing this, and that's how I'm communicating with clients.
I think that's a logical and reasonable interpretation, Mike, and that's like we said, we've been talking about this since the regulation came out and what it might mean. And while we don't have, as Mike said, any official authority, and expect to end up discussing, if not debating and arguing with counsel opposite at some time in the future, I think it's a very solid way to approach it in terms of relying on the general principles of statutory interpretation. Okay, so our next question then. So there have been a few questions about reduced hours, and how does the change in legislation impact those employees who might be on reduced hours? Are they affected in the protected leave sense?
I'll jump in again just because I have the regulation in front of me. Section 4 of the regulation, subsection 1, paragraph 1, specifically says the employee's hours of work are temporarily reduced or eliminated. So yes, an employee whose hours are reduced but who are not fully 100% on a layoff, this regulation still applies to them. I have to assume this means that they are on a job-protected temporary leave of absence when otherwise they would be working. So if they're working half the time, the other half the time, you know, it's not a layoff the other half the time. It's not a termination the other half the time. it has to be some kind of a job protected leave of absence half the time. And that will extend, again, 6 weeks beyond the end of the state of emergency.
So Mike, how does that apply in a case where the employee's already working reduced hours before the COVID-19 period? So for example, maybe they're a full-time employee, but for some period of time, they'd been working something less than full-time. How do we, what's the method of calculating whether the hours have been reduced in a circumstance like that?
Good question, and I don't think we have guidance on that yet. I mean, what the Employment Standards Act says about a layoff is a layoff occurs when an employee is earning half of their regular earnings. And, some employees don't have regular earnings, so to speak. They don't have a set schedule that's the same every week, so we have to kind of take a longer view of it and do the appropriate calculations. It doesn't say what degree the hours have to be temporarily reduced. It just says that if hours are temporarily reduced by the employer for reasons related to the designated infectious disease, they are deemed to be on this job protected leave of absence.
So would we look at a particular period before the reduction to calculate what their normal hours would be? I mean, we may have people who have irregular hours, for example, from week to week.
That's what we would do in normal circumstances.
Yeah,
right?
so how does that work normally then? Even if we're talking about a temporary layoff as opposed to
if I'm
leave of absence.
remembering correctly off the top of my head, we take a look at the 12 weeks prior to the layoff or reduction in hours during which the employee actually made money, actually got paid by the employer. We take the average of those 12 weeks to find out whether there is a reduction in the hours. Okay.
I think that's probably, to me, that would make sense as the normal way we might approach that question here, and the determination about whether there's actually a reduction. But I guess we'll see as that gets interpreted.
Yeah. Rob,
yeah,
I know I think you touched on this in your presentation. There's a question from Sean from before we switched over to the Q&A. I don't know if you had a chance to take a look at it, but it's about modified duties and whether lost time might occur. Did you get a chance to look at it?
Yeah, so I think Sean's question is something that I did answer in my commentary about what happens with employees who were on modified duties or on reduced hours because of a workplace injury before the COVID-19 period begins. So the WSIB has again made it clear that they're going to treat them the same way they were being treated prior to that what we were calling a layoff at that point. So the layoff and now the protected leave it may result in a loss of income for the employee, but that a loss of income would not be considered to be related to the injury. It would be related to the special circumstances of the pandemic. So in that case, if the employee is doing modified work at full hours, you're accommodating that person, they shouldn't be receiving loss of earnings benefits from the WSIB, and so that would continue even after the layoff that's not related to the injury. Of course, you have to look at the specific circumstances of every case. So if in fact the business is continuing to operate, but the decision is made to eliminate the work of that employee who could otherwise have been accommodated, even during the pandemic, then it's possible that the injury might be a factor in the actual loss. So there may be some specific cases where that's not the case. But once we get out of that COVID-19 period, and businesses start bringing people back to work, we may start looking at that a little bit differently in terms of what the long-term economic impact is on that employee, or if the employee is permanently laid off or dismissed because of the financial impact on the business, but still is disabled or is permanently disabled, then the WSIB will look at that case with a bit of a different lens at that stage. you know, in terms of the costs associated with the employee's prior claim or injury, that really is a very specific question that depends on the circumstances of the employer. So it's difficult for me to answer that specifically. So I think I would have to take that response offline in terms of sort of business decisions about whether should we bring someone back to modify work, even though it might not be economically feasible in the normal circumstances, just because we're trying to avoid a loss of earnings claim. I think that's going to be very employer specific.
Right. And then before we move to the next slide or next question on the slides, I'm going to take a second to answer John's question, also from before we switched over. And if anybody's looked in the Q&A, it says, good morning, based on regulation 288-20, employers will be able to temporarily lay off employees after the end of the COVID period if their business is unable to open immediately thereafter. This was probably addressed in the first question that Mike answered, but certainly, the regular rules as Mike set them out in terms of our ability to lawfully lay off an employee will apply once that COVID +6, I guess I would call it a COVID +6, although I guess the whole thing is the COVID period for the purposes of when the IDEL expires, but certainly the normal rules will apply after that, because unfortunately there will be employers who will not likely be able to open at full capacity or get hit the ground running, so to speak, right off the bat. Okay, so next question then. How does the new regulation, specifically the protected leave, impact employers if they're planning to terminate someone's employment who has been on a layoff as a result of COVID? So this is a common one, not only that we've gotten through the webinar, but also from clients asking directly as soon as this came out. Part of what's been happening is employers have had to make some tough decisions, either for immediate implementation or implementation down the line as they realize the realities of coming back after this. So the two questions on here are related. They came from two different sources, but I think they can be addressed together. Who wants to take this one? I know, Christina, I see you nodding your head. Let's see if we can. Are you able to get your audio going? No, it doesn't seem that way. No, sorry, Christina, we're not hearing you at all. That's I know you have thoughts on this. Mike or Rob, either of you guys want to take this?
I do, but I've somehow switched my screens around and now I can't read the questions anymore. Hold on. So, okay, here we go.
Yeah, okay.
How does the new regulation, specifically protected leave, impact employers if they are planning on terminating someone's employment who has been on layoff as a result of COVID? Okay. Well, if an employee is on a job protected leave of absence, the kind that the provincial government has imposed in this regulation, they're job protected. They actually can't be terminated. Except maybe if we think a little bit creatively and flexibly and work out a plan directly with the employee, so that they would accept a package. And when I say accept a package, now I'm thinking of what we would do under normal circumstances with an employee that we need or want to terminate, but we don't have just cause to do so. We make a proposal on what the appropriate notice period would be, and notwithstanding that we don't have to pay that much money, we say we will do it if you sign back a full and final release of any claims against the employer. that requires obviously the employee to be a willing participant in this kind of a deal. If they are not, they rely on the fact that their job's protected. And during the COVID-19 period, state of emergency +6, I think, is a good formula for it. You do not have the ability to terminate that employee.
I guess I would take a bit of a different view than Mike on some of that, and maybe we can have a debate about that. But I mean, if we talked about other types of leaves that are protected under the Act, so the one that comes to mind to me is a pregnancy or parental leave. The employee has the right at the end of the leave to come back to the position if the position still exists, of course, and then there are other rights in terms of return of that employee to that position. But employers are not prohibited from ending the employment for reasons that aren't related to the leave itself or the pregnancy or parental leave. So, for example, if my business is shutting down, if you've gotten to a point where you can't bring anybody back, that employment will be terminated, and it'll be terminated in the period of the protected leave. But the reasons for the termination aren't because the employee has taken a leave. So that's the defense essentially to the breach of the right to the leave. So I think I could see circumstances, particularly where the business impact on employers is extreme, that there still will be opportunities to make permanent decisions about elimination of positions. But I mean, maybe Mike will disagree with me on that.
Well, and let me pipe in for a second here, Mike, because I think maybe there's not necessarily a difference from a legal perspective in terms of our entitlements and obligations, but from a risk perspective in terms of which scenario it provides more risk. And I think in that one that you've just described, Rob, which is more what we're looking at in the second bulleted question here, I think there's less risk when you've got that obvious and clear business justification than simply proceeding with a termination that was already in the cards. I mean, I think Mike's points are well made and well taken as well with respect to if they're on that leave, you're running a big risk by just terminating. And that begs the question, well, then do we have to recall them and then terminate? Well, if you're only recalling that one person and then terminating, that also, the risk and the perception, as we know, adjudicators, whether by statutory obligations, such as in the Human Rights Code, or by virtue of the, I'm trying to find a politically correct way to say it, but by virtue of the general leanings of adjudicators in the employment sphere, the presumption is often in the employee's favor, where at first blush it looks like there's been a violation, right? So I think it's more about the risk and what you can or can't do and to offer a defense, like Rob said.
Yeah, and I think like all the things that we've been talking about, we're going to build some experience as these issues get raised and argued. But the infectious disease leave before this regulation spoke specifically about certain events that would trigger that leave, like the employee became sick or required to take time off work to provide health care because of the pandemic. So those specific circumstances, I think, are different than those employees who we had already laid off in the general sense on a temporary basis, and then they're now deemed to be on that protected leave. So I think I agree that it's all about the management of the risk. And so some of the timing of those decisions, I think, is important. And there needs to be some clarity that you're not isolating an individual employee that would elevate that risk of terminating the employment. But I think we're going to see, because of the incredible economic impact of this pandemic, we may see a lot more leniency in terms of how those defenses of employers might be considered if an employee said, "Well, you fired me while I was on leave, and so therefore you've breached my rights under the leave period." To me, it's similar to the kinds of arguments that we've already talked about as to whether the common law around constructive dismissal would be applied in these circumstances. We have to understand the full context of the situation that we're all in, and Mike is absolutely right that the protected leave is protection against losing your job because you've taken the leave. But then there's still a question of, is that why you lost your employment? Is that why the business decided to end your employment? It's not because you took the leave, it's because we're hemorrhaging money and we have to shut down operations, or we may have to actually close our businesses. And those realities will have to be considered when we start talking about the decisions that employers make. But if an employee is on a leave of absence and you're not paying them during that leave of absence, one question you might ask yourself is, what's the urgency of pulling the plug on the employment now that they're on the infectious disease emergency leave? Is that a decision we can reach at the end of the COVID-19 period when we've got all of the data that's relevant?
So that segues perfectly into Bridget's question that just came through, Rob. And anybody, and I see Christina's back, hopefully with the ability to be heard, where employees have been laid off in April and May as a result of COVID-19, and then permanent terminations happened. And obviously, there will be some specific circumstances that we would want to know, but in a general sense, what do employers do if they made those decisions based on that, and will the kind of retroactive application of this regulation affect them negatively? I see everybody's reading the question in the Q&A there. Christina, thoughts now that we can hear you?
So I'm hoping you can all hear me now. Apologies for the technical difficulties there. So I seem to have lost my Q&A access, but from what I'm understanding, I think the question is, if prior to the introduction of this regulation, decisions were made that either the layoff period had elapsed or was going to, and terminations followed, and what do we do now? Is that the gist of the question?
Yes.
We've already terminated and paid them out, and then this regulation came in to apply retroactively.
So the regulation is clear that if there has been a termination already, the employee is not retroactively deemed to have been on the leave. So that termination still applies. However, it does seem that there can be an agreement between the employee and the employer to perhaps rescind the termination notice. If you've already paid employees out, that gets more complicated and perhaps is a question to take offline. But generally speaking, if those termination notices have gone out, if the employment relationship has already been severed, the regulation will not retroactively reinstate that employee or nullify that termination.
Thanks, Christina. Makes sense to you, Mike?
Yep.
Okay. Let's move on then. I think, and we're close to wrapping up here. Thank everybody for sticking with us and their patience. This is a common one here, and we saw it come through the Q&A, and we saw and this is about returning people to work and whether or not they come in, or sorry, whether they come back. Oh, sorry, everyone. So if they're called back and there is work, but they refuse due to non-COVID reasons, is this in any way any different from what we would normally consider at least exploring the idea that they've abandoned their employment?
So I can jump in on that one again, make up for lost time, as it were. I would say no. If the employee is refusing to come to work and it's not tied to any of the entitlements that would give rise to a job protected leave, and just as a reminder, that does include things like childcare obligations or caring for family members who are sick with COVID-19, then I think you're in the normal circumstances again, where they can be considered to have resigned or abandoned their employment. That said, use caution when making that determination. I think as employers, everyone needs to be a bit sensitive to the fact that perhaps there's some fear among the workforce, and being sure to manage any anxieties, uncertainties by making sure there are clear policies in place about the steps being taken to prevent any infectious disease issues in the workplace. So I think that's a good start. I also think you need to do some work in inquiring as to why the employee is not willing to come back. So again, if there's, say, a care obligation that they have, that employee might not be articulating to you that their reason for not returning to work is tied to COVID-19. Maybe they say, I just can't do it. I have things going on at home. So as an employer, I think you do have that duty to inquire. Just make sure there isn't an entitlement to that leave that might be missed. But otherwise, if it's just, I'd rather have the CERB, I'd rather not return, then the regulation wouldn't change that in any way.
Okay, and I think that's a good point, Christina, and it's the corollary of what we've been talking about today in terms of the special considerations, right? Rob mentioned it in the last question that we addressed, and just as we expect the courts to take special consideration of the circumstances, we as employers have to do the same thing, and not just give you've said no, you're out of here. You've said no, and I know you don't check any boxes or anything like that. I think an employer who does that is doing themselves a disservice in these times, at least. So I think that's a good point to me.
I would also mention this is something that we did cover in our previous webinar, episode 16, on reopening for business during and after COVID-19. I think a related issue, and Christina, you did touch on it a little bit. What if we have an employee who says they have some fear of the workplace itself being unsafe? How do we address that kind of a situation where the employee says, I'm concerned that if I come back to work, I will be exposed to potential COVID-19, and that is the reason I am refusing to come back to work?
So I think there are two ways that can play out. So if the employee is able to tie their fear of the workplace to the physical condition of the workplace, they're able to point to, say, we haven't implemented the appropriate policies, members of the public are coming in, social distancing can't be maintained. If there's something that the employee is pointing to about the condition of the workplace, that may become a work refusal, and the process would need to be followed in that case. So you would need to do an inspection, perhaps involve the ministry if things progress. But on the other hand, if the employee is just saying, I think that going to work will put me at a higher risk in any event, and it's not tied to the condition of the workplace, it's not tied to any policies, we've had guidance so far that those types of work refusals will not be upheld, and that a general fear of COVID is not sufficient to justify a refusal to return to work. But again, an important caveat is if an employee is coming to you and saying, for example, I have clinical anxiety, I cannot return to the workplace because this has become an issue for me, here is my doctor's note. That might be where the accommodation process is being triggered and you need to go down that route. So as I've been saying, I think the real advice here in any circumstance is just make sure you're taking an individualized approach with employees if they're refusing to return.
Thanks, Christina. I think that makes sense. Anyone, before we move on to what I think will probably be our last or second last question, if we're returning them and it is a job protected leave, does that mean that the normal considerations in terms of the same hours apply?
Well, the regulation says that it's a job protected leave, even if their hours are reduced or even if their hours are eliminated. Based on that, I don't see any requirement that an employee be reinstated to their full-time hours while this leave of absence is in effect.
Thanks, Mike. That makes sense. Okay, what do we have here? Let's see. Okay, so that's the end of our slides. And I'm just looking here. We have one last question that we have not yet addressed, which was a contract with a specific end date. And for the purposes of this discussion, we'll assume it was valid and in the defined term contract requirements under the ESA. Who wants to take this one with respect to, is it an issue that their contract expired during the time that now is retroactively considered to be a job protected leave? I think this would be addressed the same way that we talked about those termination decisions that were made prior to the regulation coming out, but
I think Christine is probably going to want to answer that, but I would say one thing that I would be thinking about is is there a potential? Let's say the end date was actually some point after March 1st, and that we couldn't reach the end date because of the pandemic. I guess one of the questions I might ask is, how would the contract be interpreted if we were litigating whether or not the employers actually complied with the contract because we've lost, period of time within the term of the contract? Is this some sort of act of God that has made the contract frustrated in terms of its performance, or should the employee continue in the term once the COVID-19 period is at an end? So there's some questions I think that would require us to take a look at the actual term contract. And I would think in a 3-month term contract for most employers, it wouldn't necessarily be anticipating those types of events. So we might not see that kind of language in that agreement. But I mean, I'll let Christina answer the general question, or Mike.
I would, Rob, I'd certainly agree with you on that. It would be important to consider the contract itself. I also think in terms of other circumstances to consider, some factors that might come into play would be, say, if there has been any communication to the employee that, say, but for COVID, that contract would have been extended. That's information I'd want to know as well. Also, just a caution with all fixed term contracts is oftentimes employers can use them for a period of time. And for example, it's a 5-year employee, but they've been on a series of 1-year contracts. I think in that case, there would be a different answer than if it's, say, a 6-month contract that simply has run its course during the COVID period, as it were. But I think it really will come down to the individual contract.
That's a good point, Christina. Sorry, Rob. Good point, Christina. If there's a series of successive fixed-term contracts with no real reapplication process for each and every one, that will be deemed to be one long, uninterrupted, and indefinite term contract. So that's a good point. I would like to know whether the contract says specifically this point on the calendar is your end date versus you will provide services for us for 3 months. Those might have two different interpretations. An employee might be able to say, I was only able to provide services for 2 weeks until the pandemic happened, and so I'm still owed 2.5 months on the back end once we're allowed to reopen, which kind of raises another issue. Is the workplace on the list of essential workplaces, and can this employee be working remotely, and why are they not working now? Were they reduced because of economic reasons? We don't think we can quite afford it, or was it that we're not even permitted to operate at this point? If it's the latter, we may have another argument, which is that the employment contract has actually been frustrated by some unexpected, unanticipated, actually, function of law that says the contract is impossible to perform. And so that's just another thing we have to consider.
Yeah, sorry, Mike. Those are all good points. Thankfully, Lynn was able to answer your questions of her. Specifically, it was their first contract and it had an end date. So that wraps that neatly up in a bow, but certainly if there are other instances, valid considerations. And thank you, Lynn. It's hard to get lawyers to stop talking, but one way is to give.
I don't want to stop talking because I wanted to say one other thing. I think generally speaking, while we answered Lynn's question, we're trying to give general advice about those types of term contracts. But a similar kind of scenario that I can imagine is not about a term contract, but that the employer has provided notice of termination, working notice of termination, with a termination date that arises after March 1st. What happens with that? It's a similar kind of thing that we've contemplated an end date for the employment, and then so we would probably address, except for the contractual interpretation language debate we had, we would approach it the same way in terms of the answers that we gave.
Okay, well, thank you, everyone. Those of you who stuck with us from beginning to end, amazing. For those of you listening or watching after the fact, we hope you've learned some things and learned the questions to ask, both of your employees, yourselves, and of us. If you need to get in touch with us, here's how. It's on the screen. If you're not viewing this, but rather listening to a podcast version, then you can find all of our contact info on our website at www.ccpartners.ca, where you can access all of our various broadcasts, contact information for all the members of our team, and sign up to receive our blog. Normal circumstances, I would say weekly blog, but these are not normal circumstances, as you heard today and have heard every day since it started, I'm sure. But the reason it's not weekly anymore is because it's sometimes daily or twice daily, depending on what is happening, and we want to make sure that you get all of the information. So on behalf of Mike, Rob, Christina, and myself, the Lawyers for Employers at CC Partners, I want to thank everyone for attending. And,
Welcome to CC Partners, the employer's choice. We provide expert legal and strategic advice in all areas of labor and employment law. By working closely with our clients, our experienced team delivers pragmatic, proactive solutions, resolving many issues before they escalate. Get to know us better at ccpartners.ca.